Good afternoon and welcome to the CRS series of talks. And we have the distinct privilege of having Professor Sharry Aiken with us today. And Sherry doesn't need much of an introduction. She's a prominent Canadian legal scholar and advocate specializing in immigration and refugee law, international human rights, and specifically on the intersection of national security and civil liberties. She's widely recognized for her work. She's currently a professor at Queen's University Faculty of Law, and her work for decades bridges the gap between academic theory, advocacy, and activism. I've known her since I was in my 20s. So she's a very esteemed colleague, but also a person that really added value to my personal life history as an academic, as a scholar, but also as an individual. She has been a leading voice on the protection of displaced persons in Canada, and a very vocal critique of the Canada-US Safe Third Country Agreement. Um, Basically highlighting the undermining of the rights of asylum seekers. She also has extensively researched how post 9/11 security measures, such as the security certificates, impacted immigrant communities and due process in Canadian law, um, and many more. So I'd welcome her to lead us through her latest research project. And I would also encourage that she talks about her work, perhaps in the Q&A about the Canadian Council of Refugees, where she was a past president, as well as some of the legal challenges that she has been involved. She's been involved in very high-profile interventions before the Supreme Court of Canada. Over to you, Sherry.
Thank you so much for the kind introduction, Nergis. I'm so delighted to be with all of you this afternoon, and especially at the Center for Refugee Studies, which was really so formative in terms of shaping my own interests, passions, and commitments over many decades. I won't say how many, but many decades. Let me begin by sharing screen. Let's see here. We are ready to roll. The topic of my presentation today, which is based on a fairly long, lengthy engagement with this project, is Equally Unequal, Intersectional Oppression and the Equality Claims of Refugees and Migrants in Canada. So I am indeed going to be telling a lot of stories from the trenches. I want to begin, though, with an acknowledgement of territory. We are gathered today virtually and in Toronto, now known as Toronto, which in Mohawk means where there are trees standing in water. Today, Toronto is covered under Treaty Number 13 and the Williams Treaties. It's the traditional territories of many First Peoples, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. These nations continue to experience ongoing colonization and displacement, where land acknowledgements are offered in place of land itself. This territory is part of the Dish with One Spoon Wampum, a treaty made between the Anishinaabe, Mississauga, and Haudenosaunee, where nations entered into an agreement to protect the land and responsibly care for its resources in harmony together. As settlers, newcomers, refugees, and Indigenous peoples, we have all been invited into treaty territories in the spirit of peace, friendship, and respect. We are also mindful of the broken treaties, as well as the global structures and systems that have continued to oppress, dispossess, and displace peoples across Turtle Island today. We turn our minds to conflicts and human rights catastrophes here at home and around the world, where struggles for land, recognition, and reparations continue unabated. We recognize our responsibilities as treaty people to speak the truth, search for peace, and demand justice, and engage in a meaningful, continuous process of truth and reconciliation with all our relations. Respect. And I do want to say a moment, I want to share just a few words for a moment on the image on this slide. It's actually by Christy Belcour, who's a Métis visual artist and social justice advocate. And the title of the image is Reviving Everything Anishinaabe. And this is what Christy Belcourt had to say about this work, which was originally a painting. The intergenerational effects of residential schools is something so many of us live with. But this is a painting about hope and revival. The bowl, Dunagan, represents the bowl of our individual lives. It's our spiritual bowl, right? And that's the bowl you see in the image there. We fill it with good things we do in our life. The strawberries represent coming of age ceremonies, such as the strawberry fast young women go on. The young woman holding the pipe and the young man holding the smudge bowl, along with the strawberries, represent the return of our ceremonies and the revival of everything we once had, the richness of our ways of life, our languages, and our connection to the land. The butterflies represent the metamorphosis, change, and freedom from the heaviness of the residential schools and the hope for the future. The flowers and plants always bring us back to our connection to the land, and the medicines and teachings they give us tell us all how to live on Mother Earth. So with that, I'd like to begin, and I'm going to start with a little bit of framing, because although I'm going to tell a lot of stories from the trenches about case law and the role of Canadian courts, I want to begin with just a brief survey of some critical theorists in the area of inequality, national borders, and immigration. And so that's sort of what's going to follow first in this presentation. So just to geographically situate ourselves, it's important to have a kind of look at historical patterns of migration and to understand that we really need to dial back the clock several hundred years to the slave trade. Often people in Canada sort of have the view that, well, Canada didn't really have a system of institutionalized slavery the way, for example, America did, or the way some other countries around the world did. But that, in fact, is misleading, because slavery did have deep roots in Canada's settlement from the very beginning. And if you take a look at the patterns of migration, you'll see that, in fact, the slave trade was indeed one of the foundational moments of migration history and has shaped the ongoing systemic racism in patterns of mobility ever since. So this slide reflects the 12.5 million people who moved not by choice, but effectively forcibly. And situating this movement in Canada, we need to acknowledge that one of the central myths of Canadian national identity is that Canada is an egalitarian, pluralist society, free from the scourge of racism that exists in the United States and throughout most Western societies. Indeed, as the Commission reported way back in 1995, racism has a long history in Canada and remains a defining feature of Canadian society. Notwithstanding the scholarship and even judicial notice of the problem of racism in Canada, there's actually been relatively little focus on racism in immigration law. Most immigration law decisions and the most widely acclaimed scholarship about those decisions actually appear to be colorblind. So let's take a look at theory, and I want to start with the American scholar Kimberly Crenshaw. Kimberly Crenshaw coined the term intersectionality in her 1989 essay called Demarginalizing the Intersection of Race and Sex, and expanded it in her foundational work called Mapping the Margins, which was published in 1991. Crenshaw's framework shows how legal and social systems fail to protect individuals who sit at the crossroads of multiple identities, such as race and gender, because laws and policies consider discrimination only along a single axis. Now, while Crenshaw didn't focus primarily on immigration, her analysis of legal invisibility applies directly to migrants who experience the dual disadvantage of racialization on the one hand and gendered subordination within state policies. So Crenshaw is very important as we consider the framing. Considering intersectional framing on immigration law more specifically, we acknowledge that social, economic, legal, and other axes of oppression and imaginaries interact with identities, freedoms, and privileges. Racism, sexism, and heteronormativity, class and ableism inform and structure all administrative decision-making in Canada, of which immigration is only one component. More broadly, we need to consider settler colonialism, namely the administrative policies that continuously dispossess Indigenous peoples from their lands, entitlements, cultural heritage, and rights, and how that intersects with immigration, and specifically how immigration laws and policies are deployed to marginalize, stigmatize, detain, and remove the so-called unwanted or undesirable. Indeed, immigration law and policies have supported a settler colonial vision of Canada since its very inception, since Confederation. And it's important to situate this with the fact that the last residential school closed in Canada only in 1996. In other words, in many of our lifetimes. So some more framing, I want to draw specifically on the work of Sharry Aiken, who's pictured in the slide here. Sharry Aiken's work both honors and advances Kimberly Crenshaw's scholarship, extending Crenshaw's ideas into international human rights and equality law, focusing on how poverty and xenophobia intersect with other disadvantages. So in an early work called The Intersectional Case of Poverty in Discrimination Law, Aiken argued that poverty functions as an intersectional condition, linking economic, social, and status-based disadvantages. So for example, gender, race, and nationality. In her book, Intersectional Discrimination, which is pictured on this slide, Aiken Aiken contends that xenophobia cannot be explained on racial grounds alone. The book blends race, nationality, religion, and class to reveal why migrants often experience exclusion that law struggles to categorize. The courts have a hard time understanding, in other words. Her work reframes intersectionality as a tool for achieving substantive equality, and she urges recognition of multidimensional disadvantage in global migration and anti-discrimination frameworks. So I definitely draw on Aiken's work on intersectional discrimination to help understand discrimination and exclusion and systemic racism in Canadian immigration law. The third scholar I want to draw on today in terms of framing is E. Tendai Achiume. Achiume is a scholar now situated at Stanford Law, former UN Special Rapporteur, and someone who's done a deep dive on structural racism and immigration. I'm drawing in particular on one work identified on this slide here, which is called Racial Borders, the one at the third bullet, where Achiume argues that borders themselves are racial structures that reproduce colonial hierarchies under the guise of neutrality. Achiume highlights how sovereignty, citizenship, and visa regimes privilege whiteness and proximity to whiteness, limiting the mobility of people from the global south. Achiume's racial borders framework highlights how international migration law constructs intersectional inequality along racial, national, and gendered lines, illustrated by, for example, the differential treatment of African migrants in Europe or seasonal agricultural workers here in Canada. Her notion that whiteness functions as presumptive inclusion exposes the intersection between race, geography, and legal exclusion. So all three theorists, Crenshaw, Aiken, and Achiume, share a commitment to exposing legal blindness to the overlapping oppressions and to achieve equality through structural recognition of intersectional harms, right? I'm going to say that again because I think it's very important to underscore. The theorists share the commitment to exposing legal blindness or the invisibilization of these overlapping oppressions that migrants and other non-citizens experience, the barriers that migrants and other non-citizens experience to achieving equality. So Crenshaw conceptualized intersectionality as a diagnostic lens for domestic anti-discrimination law. Atre applies it to global equality frameworks, including poverty and migration, and Achiume reinterprets it as a structural critique of racialized global mobility regimes. And we'll come back to that structural critique when I talk about the Canada-US Safe Third Country Agreement a little bit later. So that's the theoretical framing. Hopefully it wasn't, too ivory towerish, but I think, and certainly it doesn't do justice to either of the theorists I spoke about, but it is, I think, an important foundation for understanding what's going on in Canada. So to revert back to some Canadian sources, I referenced the concept of substantive equality, and I want to explain what it is before diving in. So I'm going to give you a definition from the Government of Canada itself. Right? Canada suggests in a public document that substantive equality is a legal principle that refers to the achievement of true equality in outcomes. So we're focused on the outcomes. It's achieved through equal access, equal opportunity, and most importantly, the provision of services and benefits in a manner and according to standards that meet any unique needs and circumstances, such as cultural, social, economic, and historical disadvantage. The document goes on to say substantive equality is both a process and an end goal relating to outcomes that seek to acknowledge and overcome the barriers that have led to the inequality in the first place. When substantive equality in outcomes does not exist, inequality remains. So I invite you to consider that definition in light of yesterday's announcement about cuts to the interim federal health program. I'm going to have a few more words to say about that shortly, but I invite you to ponder that in the meantime. So patterns of behaviors, policies, and practices that may involve the direct targeting of equality-deserving groups or adverse effects discrimination, which is another term of art, that's where seemingly neutral policies and practice normalize and tacitly condone singling out such groups for adverse treatment. Okay, these are basically the ways in which systemic discrimination happens in Canada. More often than not, through seemingly neutral sounding laws and policies, and indeed the cuts to the interim federal health program is a perfect example. It doesn't target any particular, sort of racial or gender category. It appears totally neutral, but on the other hand, it has very differential effects, and we're going to talk about that. So the kind of central heart of this presentation is a bit of storytelling, and it's to take you through a series of very foundational cases to explain what the courts were up to in various cases that addressed migrant rights one way or the other, and their intersection with this concept of substantive equality. And I want to acknowledge at the outset that it's primarily a bad news tale. But we're going to start with the one sort of equality rights victory in immigration law since I've been active in this domain. And you'll notice that it involved a white man. Indeed, the case was also brought forward by another lawyer, a white woman. So there were two white lawyers. This case challenged the provision of the BC Law Society that only citizens were permitted to be members of the provincial bar. Both these lawyers were educated outside of the country. They were not citizens, but they wanted to become members of the Law Society of BC and practice law in BC. And together they challenged the exclusion of the BC Law Society's regulation. And it was a win. The Supreme Court of Canada agreed that non-citizens were a historically disadvantaged group lacking in political power. And the court went further to say that discrimination on the basis of citizenship is analogous to the specifically enumerated grounds of discrimination in Canada's Charter of Rights and Freedoms. So even though Section 15 of our charter, which is the section that actually prohibits discrimination, doesn't specifically identify citizenship as a prohibited ground of discrimination, the court said it doesn't matter. It's an analogous ground. And we agree that these two lawyers should be permitted to become full-fledged members of the Law Society of BC and practice law in Canada. And everybody thought this is a great decision. This means that status-based distinctions affecting other types of non-citizens will potentially have an open door and a warm reception at the Supreme Court of Canada. But I want to tell you that was not to be. From the high water mark of the Supreme Court of Canada's decision in Andrews and Law Society in BC, we immediately plunge in the other direction with a case that I actually didn't put a slide on, but I'm going to tell you about in a few minutes, which is that of Chiarelli. So Chiarelli was a decision of the Supreme Court of Canada that happened hot on the heels of Andrews just a couple years later. Mr. Chiarelli was born in Italy in 1960. He came to Canada when he was a teenager with his family as a permanent resident. And for whatever reason, we don't know why, his family never applied for citizenship. That's often a common phenomenon. Many people don't realize that not being a citizen is actually a pretty significant disadvantage, because if you come into contact with the criminal justice system and you're not a citizen, there can be dire consequences for your status, namely removal from Canada, no matter how long you've been in the country. And sure enough, 9 years after Mr. Chiarelli came to Canada as a teenager, he had a very serious brush with the criminal law that stemmed from drug trafficking. And as a result of the conviction for a rather serious drug trafficking offense, Mr. Chiarelli got caught up in the immigration removal system. He tried to challenge it on, among other grounds, equality grounds. He said, look, I've been in Canada since I was a teenager with my family. It's not fair. It's not just that you're subjecting me to the prospect of deportation for an offense that other Canadians would end up simply serving, a defined sentence for and be allowed to get on with their lives. So, in other words, he tried to deploy Section 15 from Canada's Charter of Rights as one prong of the challenge that his counsel launched to the idea that he should be deported. He lost. And Mr. Justice Sapinka of the Supreme Court of Canada said some words in rendering the negative decision in Chiarelli that came to be a kind of haunting specter over all the immigration and refugee case law that has followed since. Mr. Justice Sapinka said, the most fundamental principle of immigration law is that non-citizens do not have an unqualified right to enter or remain in the country. Okay, do not have an unqualified right to enter or remain. So the idea of that framing is that non-citizens, by virtue of their status, are accorded different treatment than everybody else, right? Now, we understand that the way that the system of borders and mobility has been reinforced and structured internationally, we don't live in an open borders world. We certainly weren't expecting the Supreme Court of Canada to say, everyone outside of Canada, you're welcome here. But what we need to understand about Justice Opinka's dicta in this case, Chiarelli, that's so problematic is it is effectively offering carte blanche to public authorities to treat non-citizens differently because they're not citizens, right? And in relation to matters that go far beyond the question of simply their immigration status, but what sort of procedures are they entitled to? What kind of remedies are they entitled to? Keep in mind that if you're a citizen and, for example, you get a parking ticket, right? You have a right to an oral hearing before a judge if you want to challenge that parking ticket, right? You have to check off the box, refuse to pay the fine, and you'll get your notice in the mail sooner or later inviting you to challenge it in provincial offenses court. You have a right to an oral hearing before a judge and a further right of appeal. And I'm not suggesting that everyone wants to challenge a parking ticket, but I draw it as a point of comparison because what Mr. Chiarelli was trying to challenge was the lack of fair process in relation to Canada's removal procedures, given that he had been in Canada since he was a teenager, that he had no ties left to his country of origin back in Italy as a young adult, and that his family was all in Canada, and that he really didn't want to leave the country, and he lost. Okay, so fast forward a few years later, and we get to the Baker case. Now, those of you who are lawyers and legal scholars, you'll be very familiar with this case. A lot of ink has been spilled on it. Let me just mention a few of the key facts for those of you that are not familiar. Mavis Baker came to Canada on a visitor visa and overstayed the visa. In other words, she didn't go home at the end of her visitor visa. Instead, she stayed and worked underground for many years. Indeed, by the time the case came to the Supreme Court of Canada, it was more than 11 years that she'd been working as a domestic worker in Canada. And she also had 4 children in Canada, children who were born in Canada and children who, in relation to the twin, she had 4, but the 2 middle children were actually co-parented with a Canadian resident. Now, she applied to remain in Canada eventually after 11 years kind of underground and under radar of public authority. She applied to regularize her status through the discretionary humanitarian and compassionate procedure. And she initiated that application, didn't have very good counsel at first instance, and the application was flatly refused. She then was lucky enough to find a pro bono lawyer, my friend and colleague Roger Rowe, who ended up taking that humanitarian and compassionate refusal all the way up to the Supreme Court of Canada, arguing that Mavis Baker had a right to a fair procedure before she was summarily deprived of the right to remain in Canada, and particularly before her children were summarily deprived of access to their other co-parent if they were all deported to Jamaica, where Mavis Baker was from originally, and that the family had a strong interest as a family to remain as a family unit in Canada, even though the 2 individuals, Mavis Baker and her former partner, were no longer in a relationship. They were actively co-parenting the twins. So what's interesting to note about this case is that you will not find any reference to race or racism in the Supreme Court of Canada's decision. But there is absolutely no question that systemic racism framed what happened to Mavis Baker, framed how various levels of decision makers, from the very first immigration officers who looked at her file to the judges that sat on review and how they considered it. There is a very well-known section in the Supreme Court of Canada's decision that actually reflects the court's reasoning about the Baker case and how sharply critical the judges were of the immigration officers' stereotypes of Mavis Baker and the extent to which they failed to consider the extent to which presumptions about, single women with children and single women with mental health challenges, for example, need to be looked at in more of a fair light. What I want to do is share with you Roger Rowe's own reflection in an article he wrote a number of years after the Supreme Court's decision. Was called Baker Revisited. Roger Rowe said the ongoing resistance to Baker by immigration authorities and some lower courts in Canada is unacceptable because it both exacerbates adverse impact of systemic discrimination and perpetuates a culture of denial. Regrettably, it would appear that persons of African descent in Canada cannot rely on the courts alone to put an end to systemic discrimination and achieve social justice. The solution to this challenge may ultimately lie in the political arena. And I just want to say this was written back in 2007, right? We're now in 2026, but I think Roger Rowe's reflections are very prescient and relevant for where we sit with the courts today. In other words, every single time there's an opportunity to deal with racism in the immigration context, courts step back. And it might have been permissible to have suggested in the past that one of the reasons courts step back is that legal counsel weren't advancing these arguments. And so, it was understandable that judges were shying away from that analysis because they weren't being fed the pleadings by counsel. But that is certainly not the case, and it hasn't been the case for years. And I want to give you the first example, which is the case of Heilwitz and de Jong from 2005, a few years after the Supreme Court of Canada issued its decision in Baker. So Mr. Heilwitz was from South Africa. Mr. de Jong was from the Netherlands. They both applied for permanent residence, respectively, under the investor and self-employed classes as set out in the former Immigration Act. So they were both coming as economic immigrants, and they sought to bring their families with them, but they were the principal applicants. Both of them were white men. Okay, now, the problem they ran into is that in both cases, they had a child, a dependent, who was disabled. And Canada's medical admissibility requirements, which continue today, require that applicants have substantial financial resources to qualify and that they can be denied admission if a dependent child, despite those resources, would cause or might reasonably be expected to cause excessive demands on social services in Canada. Now, excessive demands is the actual norm in Canadian immigration law. A series of policies define what an excessive demand actually constitutes. And it used to be that the threshold for excessive demand, back when Heilwitz and de Jong's case came to the Supreme Court of Canada, was quite, the law set the threshold in quite low, which meant that even a modest demand was considered excessive. Successive periods of government loosened the definition of excessive demand to say, well, it's not excessive demand unless it's over a much larger amount, right? So they were quantifying excessive demand in favor of prospective applicants and saying, we'll only exclude your disabled child and your whole family if, they're going to be very expensive. Okay. Now, Heilwitz and de Jong didn't attempt to challenge fundamentally the concept that it was okay to discriminate in relation to disabled immigrants. They didn't challenge that. They said, What's problematic about Canadian immigration law is that we have the ability to pay for all the expenses our disabled children will need, and you should allow us to come because we can pay for it. And you know what? The Supreme Court of Canada kind of agreed with them. They rejected this blanket approach to denying applicants based solely on their disability, based solely on whatever medical condition they have. The majority of the Supreme Court of Canada held that individualized assessments should take into account other factors, namely one's ability to pay for the cost of social services. That's relevant to the anticipated impact on social services or what should constitute excessive demand. Now, Howitz and DeYoung were obviously delighted because what that meant is their ability to pay for the needs of their dependent children gave them a welcome mat. The problem was that it closed the door shut on anybody who lacked the resources that Howitz and DeYoung had. Now, there was an NGO intervener in this case that brought a systemic analysis to the case and argued that deploying an intersectional lens helps us to understand that the very concept of excessive demand has disproportionate impacts on certain categories of prospective immigrants and ultimately constitutes impermissible discrimination under Section 15 of the Charter of Rights and Freedoms. And I want to tell you that if you read the Supreme Court of Canada's decision in this case, you will find barely a mention of this argument. The court gives it no time. Madam Justice Abella, in writing the reasons for the majority decision in this case, does an extensive analysis of Canada's medical inadmissibility provisions, critiquing the sort of historic exclusion of Canada's early immigration acts, which actually made reference to the exclusion of quote unquote imbeciles embedded in the text of Canada's early immigration law. That's critiqued. Well, at the same time, there's zero recognition of how problematic an excessive demand provision in Canadian immigration law actually is. And I mean, I invite you to think about it in light of the commitments that Canada has made to the UN Convention relating to the rights of all persons with disabilities, right? We've actually committed to treating and ensuring in law, policy, and practice that we don't discriminate on the basis of disability. And yet it's very clear in immigration law that we continue to do so. Howitz and DeYoung as a decision is still good law in Canada. Okay, so we'll flash forward to another case. Nergis mentioned in the introduction my work on security certificate procedures. For those of you that haven't heard about this before, this is basically a procedure embedded in Canadian immigration law that dates back to the 1950s and before, although it's taken different shapes over the years. But it's a procedure that allows the government to sign a certificate in relation to a non-citizen requiring their mandatory detention and tracking them into removal on the basis of secret evidence that the individual concerned never sees. And what you see in the slide here is an image of Mr. Adil Sharkawi, who was one of a group of Muslim men who attempted to challenge these procedures that were deployed increasingly in the aftermath of 9/11, right? Targeting anybody who seemed to be, a potential Al-Qaeda associate, even on the flimsiest of bases. People were effectively being rounded up in Canada as they were being rounded up and targeted in the United States. And so this case was an attempt to challenge this practice, was an attempt to say it is not acceptable to lock somebody up on the basis of information they never have an opportunity to see themselves. It's not acceptable to put somebody in removal whose, only alleged offense is based on hearsay. It's not based on activities, even in Canada. So what you see on the slide on the right-hand side are actual documents that were used to support the case against Mr. Sharkawi in actual redactions. So that's what you see there. All the black is redacted, which makes it very difficult for people like Mr. Sharkawi to challenge the basis of their detention and Canada's removal plans for them. So this was a wide-ranging challenge of Canada's procedures. And an argument in relation to the inequality of this scheme was front and center of the Canadian Council for Refugees intervention in this case. And it's one that I happen to have the privilege of representing before the court. And indeed, amongst the long line of interveners in the case, it was decided that we should go first. Why? Because everybody thought this was an important opportunity to raise equality rights in the context of egregiously discriminatory laws, right? And when I say egregious, I want to put the emphasis on this. If somebody was alleged to be a security threat to Canada and they're a citizen, right? And there was secret evidence that suggested that they were seen associating or fraternizing with a known Al-Qaeda operative, for example, which is all it takes to get you caught up in this dragnet. If they were a citizen, then the Canadian government could opt to pursue criminal charges in relation to conspiracy to commit terrorism, to facilitate terrorism. There's a whole range of what we call inchoate offenses in the criminal law of Canada. They would be potentially charged. They would have a trial. The government has the right to withhold evidence in that kind of procedure as well, but it's subject to a far more rigorous process where under the Evidence Act, Canada has to justify line by line every redaction, and judges presiding over those procedures don't give the government a carte blanche to get away with not sharing the basis of the allegations. So we take, for example, the case of somebody alleged to be involved in the same kind of activities as was alleged in Mr. Sharkawi's case. They were convicted of conspiracy to facilitate a terrorist activity, and they served 6 months in jail and were released and went about their life afterwards. In other words, if you're a citizen charged with these kinds of things, you have your day in court. If you are found guilty, the criminal law determines an appropriate sentence. You serve your sentence and you continue on about your life. But anybody who's a non-citizen doesn't have their day in criminal court. They instead are subjected to these star chamber-like procedures. Now, this case was a success in the sense that Mr. Sharkawi won. He was indeed vindicated in some of the arguments that this procedure was not fair, that it violated rights. But he didn't win on the equality argument. In other words, the court rubber stamped the fact that it's okay to treat non-citizens differently than citizens when it comes to threats to national security, despite the dramatically disproportionate effects on the individuals concerned. Now, I will tell you, Mr. Sharkawi is still in Canada. I will also share with you that these really horrendous security certificate procedures have not been used recently by the Canadian government. Instead, they're finding other ways to detain and deport people, not using the security certificate procedures. And this is one more way, or one more example, I should say, of how sometimes victories in courts don't actually translate to meaningful victories on the ground. And that's always something we have to keep in mind as lawyers keen on engaging in test cases. So I'm going to say a few words about Canadian Doctors for Refugee Care. And it's particularly relevant because it arose after Stephen Harper's government curtailed and in some cases entirely eliminated the provision of healthcare coverage to various classes of individuals under the interim federal health plan. So these changes curtailed access to refugee claimants, in particular, from the sort of spurious category of people coming from designated countries of origin. And this was a kind of category baked into immigration law. So what's interesting about this case is that it was headed to the Federal Court of Appeal when Justin Trudeau actually came to power as Prime Minister back in 2015 and settled the case and restored interim federal health coverage to refugee claimants. This was considered a huge victory. I find it particularly ironic in light of the recent announcement yesterday that we're actually seeing a Liberal government backtrack and impose a new co-payment requirement for medications and supplemental services, including counseling, physiotherapy, vision, and dental care under Canada's interim federal health program. So again, we're seeing the introduction of barriers to care for refugees. So while this case had a happy ending back in 2014, certainly it's an ongoing issue. And given the time, I'm not going to go into the details. I'm going to actually fast forward through a couple more cases because I want to actually spend just a last couple of minutes on two more cases to share with you. The first one is the case of Nell Toussaint. And I'm actually going to share a description about this case from a recent article by my colleague at the University of Windsor Law, Dr. Vasanthi Venkatesh. She wrote in a very critical essay, No Status, No Race, that Nell Toussaint was a Canadian citizen who arrived in Canada from Trinidad. In about 15 years, she would also find herself as a Black woman in a wheelchair before almost all white, able-bodied Canadian courts. Denied health care due to her immigration status after changes in the interim federal health program, Toussaint suffered severe health consequences, including the amputation of her leg and the loss of an eye. On judicial review, the Federal Court of Appeal ruled that immigration status could not be either an independent or intersectional ground for discrimination because it's a mutable status. That means it changes, and the enumerated grounds had to be unchangeable. So because those grounds were changeable, that left Nell Toussaint without a remedy. She then successfully challenged Canada's denial of health care at the UN Human Rights Committee. The committee found that Canada was in breach of obligations under the International Covenant on Civil and Political Rights. Okay. With that victory, Nell Toussaint went back to the courts to try to restore her coverage and also to restore her immigration status. And sadly, Nell Toussaint passed away in 2023 at only 53 years of age. And there's no question that the denial of healthcare coverage to her when she was in acute distress physically directly contributed to her death. There is a lawsuit that's ongoing in an attempt to highlight the inequality embedded in Canadian law that denies any individual physically present in Canada from basic health care. And that case is ongoing, as I mentioned. Finally, I want to talk about the Canada-US Save Third Country Agreement. This agreement probably needs no introduction to most of you in the seminar today. It's an agreement that was ironed out in a very different context when Canada and the United States were closely engaged in joint border enforcement in the immediate aftermath of 9/11. And many groups, including the Canadian Council for Refugees, have been struggling to challenge the agreement ever since, because on the ground, we see the devastating effects of turning back refugee claimants seeking to come to Canada back to the United States. Long before the Trump administration came to power, even the first Trump administration, there were concerns that the United States, in its asylum law, was actually not providing meaningful protection to many categories of refugee claimants, right? So this is not a new concern. When the latest attempt to challenge this case, which included a very strong equality rights analysis, came to court, at the federal court, the case was successful. Unfortunately, the court failed to address the equality arguments. The court came to the conclusion that the agreement violated refugee claimants' right to life, liberty, and security of the person, and that was enough to say that the agreement was unconstitutional. We don't need to worry about the equality rights arguments. Not a very happy moment for the structural racism and discrimination embedded in Canadian immigration law, but it was a win nevertheless. Of course, the government appealed, and the Canadian Council for Refugees, Amnesty International, and the Canadian Council of Churches, which were in a coalition around this case, cross-appealed because we wanted to bring back the equality rights issue. At the Federal Court of Appeal, what did Mr. Justice Stratas have to say? He said, well, courts are empowered to abandon issues that are unnecessary to the outcome of a case. And he went on to say, the equality rights provision of the Charter doesn't enjoy superior status in the hierarchy of rights. While anxious scrutiny in this area is called for, in the absence of factual findings, a Section 15 analysis wasn't justified. So once again, we see a short shrift given to any kind of equality analysis. Well, it's not the end of the story because the case does land in the Supreme Court of Canada. That's an image of Mr. Justice Kassir on the left. And the one thing that was positive about the Supreme Court's decision, while not finding the agreement unconstitutional at this time, Justice Kassir did mention that the Charter shouldn't be treated as if it established a hierarchy of rights in which the equality provisions occupy a lower tier. And he said that the Section 15 question needed to go back to federal court for redetermination since Madam Justice MacDonald didn't deal with it at first instance. And he went further to say that nothing in the Supreme Court's decision should be taken to decide factual or legal questions relevant to the equality rights challenge. So, equality rights cases are ongoing in Canada, right? Everything from the exclusion of refugee claimants from subsidized daycare in Quebec, that was the Kenyinda case in the Supreme Court of Canada, to the situation of immigrant detainees. Detainees under the immigration law who are often subject to indeterminate periods of detention. In this case, Mr. Alvin Brown was locked up behind bars for more than 5 years, right? And Canada is one of the few countries around the world that doesn't have a statutory bar on the length of detention. So you go into jail and you don't know when you're coming out. And in that regard, I want to mention as well, we can't talk about detention in Canada without mentioning the tragic circumstances of Mr. Hassan, who actually died under Canadian custody, not in a detention center. He was shuffled off to the Lindsay Hospital as a result of the very, very serious health condition he found himself in. But he had been jailed in a provincial jail and not getting the treatment he needed. And that really underscores the fact that detention, which is ultimately a deprivation of one of the most fundamental human rights, that of liberty, is a tool that racialized non-citizens experience to far greater proportion than non-racialized citizens. And it is also to say that racialized citizens with mental health or even other health issues are subject to compounding effects of the exclusion embedded in Canada's detention practices. So I'm going to end with just leaving you with a whole bunch of questions about how deeply discriminatory Canadian immigration law is, whether it's in the economic class, whether it's medical inadmissibility, detention, whether it's categories in immigration law that subject national origin profiles to certain types of immigration treatment, schemes like designated country of origin, and other unequal access to healthcare and social entitlements. These are all the ways that Canadian immigration law discriminates. And the conclusion inescapably is that the intersecting and mutually reinforcing dynamics of race, gender, class, and ableism are deeply imbricated in Canada's immigration and refugee programs and unfair and oppressive immigration laws and policies. This is, in a word, administrative violence by the state, to give a nod to U.S. scholar Dean Spade. So I'll end by saying that inequality and racism underpin the federal immigration program, and they also mark the constitutive boundaries of law and place limits on its possible use as a tool for achieving fundamental change. The task of forging inclusive, anti-racist immigration laws has to be a profoundly political struggle, which is not to say there isn't a role for courts and lawyers, but it is to recognize 30 years of test case litigation has failed to advance equality jurisprudence on behalf of migrants and other non-citizens. So I spoke a little bit longer than I had expected, but I look forward to your questions, comments, queries, etc.